See the man won't stay for your meal, getting on a piece of pie for your wife. Everybody wanna know how it feels.
Alhamdulillah wa salamu ala Muhammad al-Amin. A'udhu billahi minash shaitanir rajim. Bismillahir Rahmanir Rahim. The Honourable President and members of the Executive Committee, learned senior members of the Bar, my learned friends, brothers and sisters. First of all, I would like to express my heartfelt gratitude to the Honourable President and members of the Executive Committee for allowing such a humble student as me to share his thoughts with the learned members of the Bar. And I would also like to express my appreciation for this admirable initiative taken by the Honourable President and the members of the Executive Committee for professional development of young lawyers. It will create a conducive environment for learning and dialogue where members of the Bar can exchange ideas, experiences and knowledge. And I think if continued, it will benefit not only the young lawyers, new entrants to the Bar, but it will also raise the collective professional standard of Rawalpindi Bar. It is indeed a commendable endeavor. Now, today's topic, as you know, pertains to procedural law. And it is, I believe, impossible to overemphasize the importance of a working knowledge and understanding of procedural law for an advocate. I believe that without such an understanding and knowledge, an advocate cannot hope to discharge his duties to his client. You must have heard the saying that procedure should provide stepping stones for achievement of justice, and it should not be stumbling blocks in the way of achievement of justice. It is true. However, procedure can provide stepping stones for achievement of justice only in the hands of an advocate who has enough proficiency in procedural law. Otherwise, it can very quickly turn into a stumbling block that can trip up the advocate and ultimately his client. And unfortunately, I have seen too many young lawyers being embarrassed by irritable judges because they are not familiar with or they do not have sufficient knowledge of the relevant procedure. The Honourable Chief Justice of Pakistan, Mr. Justice Imran Hassan, was one of my teachers at Punjab University Law College, Lahore. And a friend of mine and I used to visit his chambers quite often. And that friend once asked Mr. Justice, Mr. Imran Hassan, as he then was, which subject we should focus on the most at law school. And his answer was simple. Procedure, he said. Focus on procedure. Procedure means the pathway that you must walk in order to secure your rights. Now, you may have a right in law, you may have a very good case in law, but if you do not know which court or forum to take your case to, if you do not know how to draft your pleadings, who to impeach as a defendant or respondent, what court fee needs to be paid, and how to present evidence, just to say a few things that are covered by procedure, then you will have a very hard time in securing the rights that you are fighting for. So what is the purpose of today's lecture? An average law graduate is familiar with CPC, CRPC, Government Shahadat Order, Court Fees Act, Court Valuation Act, and so on, and even to some extent perhaps Civil Court Ordinance, because you are taught those subjects to some extent at law school. But that is not the case with the High Court rules and orders, which now equally perhaps in some cases more important are not taught at law school. So that means that you have to familiarize yourself with this very important legislation when you start your career on your own. In my experience, a lot of young lawyers simply rely upon hearsay knowledge. Hearsay knowledge, they hear a thing from some senior here, they hear another thing there, and that's about it. They are content with that. They do not go and open the book. And what does that mean? It means that they sometimes know what the law is, and they may be right in that. But if you ask them, they find they're not quite able to put their finger on that provision which actually states the law. And in my experience, this Sina knowledge is not enough. You go before the court and you cite a principle of law. I've heard many young lawyers say, well, I've heard it from the seniors. But the thing is that in practice, and my learned senior friends will agree with me, that you have to sometimes read the law, reread it, maybe read it a dozen times before you actually understand what it means. The word of the law is very important. It recently happened to me. I was engaged in a case in which an ICA had been dismissed. During Ramadan, I was engaged to file a CPLA against a civil petition for leave to appeal against it before the Supreme Court. When I read the judgment authored by a very, very competent judge, I first thought that it was very difficult to file a logical CPLA against it. I spent my entire Eid in that worry. I thought I had no case at all. To an extent, it ruined my Eid as well. I was thinking about it constantly. But then after Eid, when I sat back on my table and started drafting the petition and read that provision again, it dawned on me in a moment of epiphany, if you like, that I had been reading the provision entirely wrong, and the judge had also, so I believe, and hopefully the Supreme Court will agree with me, the judge had also misread it. And it all hinged upon a single word. In that particular case, the distinction between a judgment and an order, an administrative order. So the real purpose of today's lecture is to give you some food for thought. You are all qualified advocates. We are all equal. It is possible that tomorrow you will be standing on one side of the rostrum and I or some other learned senior member will be standing on the other side of the rostrum. So we are all equal. The real purpose of today's lecture is to give you some food for thought and to hopefully kindle an interest in you to go and read the rules yourself. You cannot just rely upon this talk or upon something that your senior tells you already. You have to read the law yourself in order to have any hope of understanding or developing a reasonable understanding of it. Enough to give you confidence to go and stand at the bar before a court and address a high court judge who has a lot more experience than you, who has read the law probably in a lot more depth than you have. You have to have that understanding to give you the confidence. Now coming to, I hope by now you have all been able to get your hands on the handout that I have distributed. For those of you who would be interested in reading the rules, I've given the link to the High Court website where you can find these rules. Now, these rules are subordinate or delegated legislation. And as lawyers, whenever you come across subordinate or delegated legislation, that is rules or regulations, the first question that you must invariably ask yourself is what is the source of the rule-making power? In other words, under what provision of law have these rules been made to determine the status of those rules? Because to make law, as you know, under our constitution is the function of the legislature. And when some other authority says that I have made these rules and this is also law, the first question that you naturally ask is, where did the legislature give you the power to make these rules? So I have started, as you can see in the handout, with the High Court's rule-making power, which in the current constitution is to be found in Article 202, which reads that subject to the constitution and law, a High Court may make rules regulating the practice and procedure of the court or of any court subordinate to it. Now you may ask yourself that this was made in 1973, but the High Court rules and orders are much older than that. So I've also listed the provisions of the previous constitution. In the 1972 interim constitution, 1962 constitution, 1966, going all the way back to the Government of India Act of 1935, all of which contain similar provisions empowering the High Court to make these rules of procedure. And then to go to the very inception of the High Court, the High Court of Judicature at Lahore, which at that time was the High Court for the provinces of Punjab and Delhi, was constituted by the letter patents dated 21st of March 1919, which were issued by the then King. And Section 27 of the letter patents also empowered the High Court in somewhat similar terms. The language there is more regal because the king was speaking there, but it essentially achieves the same purpose. It empowers the newly created High Court to frame these rules. And then in the Code of Civil Procedure 1908, you will also find Section 122, which with slightly different language also achieves the same purpose. It reads, as you can see from your handout, the High Courts may, from time to time after previous publications, make rules regulating their own procedure and the procedure of the civil courts, subject to their superintendence, and may by such rules annul, alter, or add to all or any of the rules in the first schedule. Now, the first schedule in CPC, as you all know, contains the orders and rules. They can also be amended by the High Court. And by means of making amendments to the High Court rules and orders, the High Court can also make amendments to those orders and rules contained in the schedule to CPC. Now, the High Court rules and orders comprise 6 volumes. 6 volumes. So there is no need to be scared. Normally, when you say volume, it means a bound book. When you say a certain tafsir of Quran is in 6 volumes, that means you will have 6 separately bound books. That is not the case here. All these 6 volumes are contained in one book, which I have here, much like CPC. The volumes deal with different subjects. Volume 1 deals with practice in the trial of civil suits. This is more or less peri materia with CPC, Kanun-e-Shahadat order. It basically brings together various legislation dealing with the procedure before the trial court. And the difference is that these rules are in a narrative form. So when you are dealing with, for example, a certain stage in the trial or proceedings, you will find in these rules, if you read the High Court rules and orders, you will find that the various provisions from CPC, Qanun Shahadat Order, Court Fees Act, Truth Valuation Act, etc., have been brought together dealing with a certain stage of the trial. And they are in a simple and narrative form. So if you read these, you will find it much easier to comprehend the relevant provisions in CPC and those other legislations as well. So you can also use this as a key to understand those rules. Volume 2 can deal with special jurisdiction and accounts, for example, guardians and wards, official receivers, succession certificates, civil court accounts, and so on. Volume 3, for those of you who are interested in criminal law, which I'm not, deals with practice in the trial of criminal cases. Volume 4, superintendence and control of lower courts, including inspection of subordinate courts, process fees, service of processes, handwriting and fingerprint examiners, malkhanas, oaths and affidavits. You might find that very useful. And prohibition of stunting, something that we should all be familiar with. Unfortunately, this provision is often ignored. Now, volume 5 is what I shall be focusing on today more, because it deals with the rules relating to proceedings in the High Court. And volume 6 simply contains forms that can be used in various proceedings, and you can use them, you can take a look at them in your own time. Now, the next thing is what should be the mode of citation of a provision contained in these High Court rules and orders. Now, although it is called rules and orders, that is a bit misleading because it is not structured like CPC. In CPC, you go to the schedule and you find orders and rules, and you can cite them as Order 41, Rule such and such, Order 43, Rule 1, and so on. But unfortunately, you can't do that with the High Court rules and orders. That would have made life much easier, but it is not the case, unfortunately. So instead, each volume contains chapters, and then each chapter contains parts, and then each part contains rules. So when you are citing a specific rule before the court, you will have to start with the volume and then work your way in or downward to the rule or sub-rule. It is kind of like the table manners, Western table manners. When we were at Thing, you have to attend some dinners, and we were not used to eating with pork and knife at that time. So they told us, the teacher would tell us when you go to the Lincoln Day, and don't be baffled by the number, because you have a lot of cutlery before you, maybe 4 or 5 glasses, a lot of forks and knives. And the simple rule was, start from the outside and work your way in. Same applies here. Start with the volume and then work your way down. So, for example, to cite a rule about constitutional remedies, you will say volume 5, chapter 4, part J, and rule such and such. For the most part, especially insofar as the procedure for proceedings for lower courts is concerned, as I've already said, these rules are fairly material with CPC and Qanun Shahadat, etc. But in addition, they provide for matters not covered by CPC and those other legislations. It was humanly impossible for me to cover all of them. As I've said, there are 6 volumes and a very thick book. This is without commentary, by the way. This is just the rule. In CPC, you have a thick book with commentary. Here, this is just a paragraph. So it was impossible for me to cover all the rules or even all the topics. I have therefore chosen the ones that I think you are most likely to encounter in your litigation, specifically at Rawalpindi bench. But it does not mean that the other rules contained therein are not as much important. It just means that you will have to read them yourself. Now, coming to the actual rules, I have chosen, I believe about 17 provisions that I shall be covering. It shouldn't take more than 40 minutes or so, hopefully. Now, the first one is that you often come across in demarcation cases or chicken cases. And you will often have heard about some senior counsel or the court saying that the officer who goes for demarcation has to fix 3 permanent marks, etc. Those instructions which require that are contained in Financial Commissioner's instruction. Financial Commissioner was the predecessor of the current Board of Revenue. The current Board of Revenue, as you know, was established under the West Pakistan Board of Revenue Act of 1957, but prior to that we had something called the Office of the Financial Commissioner. And on the request of the High Court Justice, the Financial Commissioner issued these instructions, which you can find in Volume 1, Chapter 1, Part M, Rule 4, and you can cite them as such. I will quickly give you an overview of them because they are probably 1.5 pages long and I cannot possibly dwell on them for too long. So, one point is obvious that he has to establish the point, the other is he has to use the field map, and then he has to compare the results with the field map. And one thing that I have noticed is the other 2 requirements are often violated. That he has to explain to the party what he is doing, and then he has to record the statements of the parties at the end, recording their satisfaction with the procedure. Why is that important? He makes the demarcation, the parties are present, doesn't follow the procedure, the parties go before the court, and then protracted litigation starts. So if this procedure was followed, probably a lot of litigation could be avoided. Anyhow, when you come across a report, you can judge it with reference to these instructions, and then maybe, if you are lucky, you could make an arguable point to argue before the court. The next is failure to seek consequential relief. As you know, that Section 42 of the Specific Relief Act says that when a plaintiff is able to claim further relief than a mere declaration, so for example, if a suit for declaration is filed and he should have sought a decree for possession as well, but if he omits to do that, then the suit is liable to be dismissed. He cannot be given that simple decree for declaration. But what happens is that in practice, people omit to do that. Courts sometimes grant a decree or they do not decide that question at the appropriate stage. And then the case comes either before the High Court or it goes up to the Supreme Court. And I've seen some judgments where the courts have to come up with innovative ways to save that suit. So, for example, they invoke principles like the party should not be non-suited on technicality, or that the claim can be amended even before the Supreme Court. If this rule was followed, all of that would be avoided. What does the rule say? Volume 1, Chapter 1, Part M, Subpart G. It requires that in a suit for a declaration of title to immovable property, where the defendant denies that the plaintiff was in possession of the property, on the date of the suit, the court should, first of all, these are the important words, first of all, meaning as a preliminary issue, decide this point. And then if the plaintiff is not found to be in possession of the property on the date of the suit, his suit must fail unless the plaintiff is amended. So if this question was decided at the appropriate stage, then a lot of time and trouble could be saved, but it seldom happens. But if you are equipped with this rule, you can call upon the court in a case to decide that question in the first instance. The next provision that I have chosen deals with Transfer of Property Act. There are some judgments that were passed in the opinion of the relevant notifications which are listed here, which say that the Transfer of Property Act, although it is such an old legislation, still does not apply to the province of Punjab. However, if you go and take a look at the Volume 1, Chapter 1, Part N, Subpart 3, it gives you certain notifications. And you will see two notifications specifically. One is notification dated 30th of December 1974, which declared that Section 54, 59, 107, 118, and 123 apply to the entire province, including urban and rural areas. Then they had a change of heart, the governor or the government, and they replaced that with a notification dated 22nd of November 1978, which now says that these sections apply to municipalities, or in other words, urban areas alone. What does that mean? These sections deal respectively with sales, mortgage, lease, exchange, and gift. And basically, they require one simple thing, that all of these transactions have to be in writing, and that writing must be registered if the property is worth more than ₹100. Now, despite the lapse of more than 100 years, we are still dealing with oral transactions, and the courts say that the Transfer of Property Act does not apply, and that leads to a lot of protracted litigation, which could be avoided if this procedure was properly followed. Now, the next provision is litigation in intra-court appeals. The following provisions now basically deal with the litigation before High Court. Volume 5, Chapter 1, Part A, Rule 4 deals with that subject, and the limitation of 20 days is provided, which starts from the date of judgment, not from the date of copy. And this is basically a reproduction of, as you can see in the footnote number 7, Article 151 of the Schedule to the Litigation Act. But the next provision is important. It says that limitation is to be computed as though there is no need to attach a copy of impugned judgment. That could come in handy in a case of urgency for you, where your restitution has been dismissed, there is some urgency in the matter, and you can go and file an ICA without having to wait for certified copies. That's how you can use it. But there might be cases where you have somehow either wasted those 20 days or were not for some reason able to file an ICA within those 20 days. The same provision says that limitation is to be computed in accordance with provisions of Section 12 of the Limitation Act. There are judgments, again I believe passed in opinion of this provision, where they have come to the same conclusion, but without reference to this rule. They stated that just because, I've given them here, just because you need not file certified copies does not mean that Section 12 does not apply. Section 12, by the way, says that time consumed in obtaining certified copies can be excluded from the period of limitation. But now you have this concrete rule that you can rely upon seeking confirmation of delay if you are not able to file your appeal within 20 days. The next provision is the remedy against office objection. Office objection raised by the Deputy Registrar Judicial. If he returns your case with objections, you may challenge that before the Chief Justice or the Administrative Judge. Now, in practice, instead of filing a miscellaneous appeal, we simply write on the objection memo, put up before the court, and the case is then fixed as an objection case the next day before the court. But this is the provision under which you have that right. In the Supreme Court, you have to actually file a civil miscellaneous appeal. Certificate of counsel in review application is the next provision. This is an extra requirement. You have to, as counsel, you have to give a specific, the judges were impressed and they allowed the application. Otherwise, I would have had to get an affidavit from the previous counsel who was not willing to cooperate, obviously, because I was substituting him. And I might have had a difficult time convincing the judge. But this rule helped me. That is an approved for reporting judgment. I have given the reference to that in the footnote. Now the next one is leftover cases. A very interesting provision which is never followed in practice. It says that there are two aspects in it. The daily cause list of the week shall be issued immediately on the preceding Wednesday. We do not receive it until late on Friday evening, or maybe sometimes on Saturday. Not giving us enough time to prepare briefs sometimes. Or at the very least, it ruins our weekend. But the next one is even more important. All leftover cases of the week shall be fixed on the corresponding day of the week following the next week. For instance, a case left over on Wednesday, the 24th of November 1965, will be fixed for Wednesday, the 8th of December 1965. That doesn't happen. You get a case fixed to an application for early hearing on that day. For some reason, unfortunately, the case doesn't get taken up. It is left over, and then you have to file another application for early hearing. And if you are lucky, the case will get fixed after a couple of months. But if this was followed, and what does it mean? It means that the cases that are now in circulation, as it were, they should first be decided. This is it is akin to another rule, the traffic principle, which is very useful principle, but never used in this country, leading to traffic chaos. When you enter into a roundabout, the cars or vehicles that are already in the roundabout, you have to give them way. In England, it perfectly works very fine, like a well-oiled machine, no problem. But here, we have roundabouts. The vehicles that are already in the roundabout, they are not allowed. We do not give them way, leading to traffic jams. So this is a similar rule. The cases that have already been fixed, they should first be decided, disposed of. That doesn't happen. Make it a Now, the next provision is notice to outstation lawyers. A very useful provision again. Useful for those advocates who do not live in Rawalpindi or other major cities that have been listed here. Basically, the seat of the High Court benches. Then you are entitled that the Deputy Registrar concerned shall fix the actual date sufficiently in advance and give to the said advocate notice thereof by a registered postcard, CC card. Such date shall not be altered except by an order of the bench concerned or of the first division motion bench if the case is not listed before a particular bench. This is also, it comes in very handy, it is useful when your case has been dismissed in default, for example, if you have to explain delay maybe. So you go and you stand before the judge and you say, I come from Atak or Iqbal and I do not have notice. And the judges are visibly irritable because they've heard all these stories. So if you refer to this particular provision and say, well, I come from a station which is outside Rawalpindi, I did not receive such a notice. So please set aside the dismissal order. It might be of some help to you if you know this rule, if you have it in hand when you go to the court. Again, these rules will be only helpful to you if you have either this book with you or if you have printed the relevant provisions from the High Court website. To have something in your hand, do not rely upon just the word of your mouth. It means nothing to the judge. Give him something concrete. So the next provision is composition or numerical strength of benches. Volume 5, Chapter 3, Part B. So the simple rule is that all cases are to be heard by single benches, except the ones that are listed here. They are to be heard by division benches, or if the Chief Justice specifically orders by a larger bench. They are regular first appeal with jurisdictional value exceeding that of the district court prescribed by the Civil Court Ordinance 1962, which after the 2016 amendment is 5 crore rupees. If it is less than that, even an RFA will go to a single bench. RFA under Land Acquisition Act, exceeding 5 crore rupees. Now these are important because sometimes these provisions baffle young lawyers. They see one RFA being heard by a division bench, another by a single bench, and they do not know which provision determines that. This is the one that determines it. So there is a list of cases. I'm not going to read out because you have the handout. The next provision is powers delegated to the registrar. This, in my experience, is the most unutilized provision that there is in the High Court rules and orders. A couple of months ago, I even drafted a letter that I intended to send to the Honourable Chief Justice that this provision should be made use of. But then, for some reason, I didn't. And maybe if the Honourable President and the senior members approve of it, we could do that. What do they do? There are many provisions in it, but a couple of them are more important than the rest. It says that the registrar, if he is someone who has judicial experience, and normally they are session judges or additional session judges. If they have that experience, then these powers can be delegated to them. What are those powers? Power to dispose of all matters relating to service of notices, including substituted service. Power to receive and dispose of an application to increase legal representative. Power to receive and dispose of an application for withdrawal of an appeal or consent decree or order. The time of the honourable judges is much too precious. It is public time which to be wasted on such petty matters. These can be disposed of by a registrar. He could be given a separate room and he could issue notices and substituted service, etc. In the Supreme Court of Pakistan, there is a corresponding provision where a lot of powers have in fact been delegated to the registrar and they are exercised by him. If you are not satisfied with them, then you can obviously file an appeal against that order. But in the High Court, they remain unutilized. And you see that there's a very thick pile of files before the judges, and a lot of them basically are ones in which notice has not been served or in which you have to increase legal representation. You come and you wait for 2 hours, and what will happen? The case gets called, and a high court judge, simply orders, okay, repeat notice. That takes 1 minute of his time, or maybe 2 minutes. But when you calculate, it all adds up. He only has maybe 2 hours, that is 120 minutes, maybe 150 minutes in a single bench. And those 2 minutes are very precious. The next provision is habeas corpus. Habeas corpus, that is when someone is in illegal detention or improper custody, you file a habeas corpus petition that the person be brought before the court. 2 provisions deal with that. 2 substantive provisions that is. One is section 491 of the Criminal Procedure Code and Article 199 1B1 of the Constitution. The power under section 491 is also essentially a power of the High Court. It is a power of the High Court which the High Court has then delegated to the session judges. Section 491 says that the High Court may from time to time frame rules to regulate the procedure in the cases under this section. And the Volume 5, Chapter 4, Part F gives those rules. One important provision is that you have to file the application on an affidavit. Now, this is ignored in practice. Counsel simply file just an ordinary petition as they would in any other case, like an ordinary writ petition. But this provision requires that you have to file it on an affidavit. At the very least, it should be a detailed affidavit. So all the contents of the petition should be reproduced on the affidavit. It shouldn't just be that formula, run-of-the-mill, 4-line affidavit. And then there are other provisions, appointment of bailiff, etc. I'm not going to read them out again because the time is precious, and you have them here in the handout. And being qualified advocates, obviously, will read them and understand in your own time. Volume 5, Chapter 4, Part J, Rule 1 states that the same rules which apply to Section 491 petitions also apply to petitions for habeas corpus under Article 199. The same rules. Which also has some implications. One implication being that although ordinarily it is said that CPC applies to writ petitions, but in this case, in a habeas corpus petition, CPC might not be of that much relevance. And this again is very important in a case I am arguing before a bench now, but I don't have time, unfortunately, to go into the details. It can be of significance that you have to argue that it is not a civil matter, it is a criminal matter. Questions of facts in writ petitions. This is very important. And I'm often very disappointed by the way that judges sometimes dismiss your petitions in limine by simply saying, well, this is a question of fact, how can I decide it? How can I decide in limine without even calling upon the other side to file an affidavit? And I submit it to you as food for thought. When does a question become a disputed question? It can only become a disputed question when one party asserts it on affidavit and the other party comes, files a counter affidavit, and then as a oath it denies those facts. That is when it becomes a disputed fact. And even then, this rule says that the High Court can decide questions of fact. This provision is often ignored. Obviously, there will be some cases in which recording of evidence will be necessary, absolutely necessary. So in those cases, obviously, a trial will be needed and repetition may not be adequate, but in most cases they are. But in any event, your petition cannot and should not be dismissed in limine without calling upon the other side to file counter affidavits. I have in the footnote given some judgments as well, but the main rule says, this is paragraph number 13 in your handout. Rule 2 says that writ petitions to be accompanied by an affidavit or affidavit in proof of the facts, and you do that. Without that, your petition will not be entertained. However, the next rule says that respondents in writ petitions should be required, when notices are issued, to file counter affidavits. I have never seen counter affidavits being filed with the comments. Officials file, if at all they take the time and trouble to file comments, they never file counter affidavits. And the judge simply says, well, this raises a question of fact, how can I decide it? You can say, the next rule says, my lord, rule number 7 says, all questions arising for determination of such petitions shall be decided ordinarily upon affidavit, but the court may direct that such questions as it may consider necessary be decided on such other evidence and in such manner as it may deem fit. And in that case, it may follow such procedure and may pass such order as may appear to it to be just. Now, in some cases, some judges, depending on their inclination, sometimes depending on who is standing before them, do make orders even for appointment of local commission to go and inspect the spot and file a report. Even in writ petitions, questions of fact, they have no qualms about appointing local commission. But sometimes, without any justification, you go and stand before them with an urgent petition and they say, well, this raises a question of fact, how can I decide it? Without asking the other side to file counter affidavit. This is the answer to that objection. The next point, and for those of you who are getting bored, I only have 4 more points to get to. The next point deals with, again, I've seen some counsels being embarrassed by technical judges, and there is no shortage of them. They say that you have either given a certificate at the end of the petition which does not disclose the fact that your client previously filed a petition. And sometimes you do not know it honestly. Sometimes your client conceals it from you, but sometimes you are not familiar with this rule and you make that mistake. Young lawyers, obviously. And you omit to give a certificate. That might be, when it does in practice, lead to a lot of avoidable embarrassment. I have seen counsels being embarrassed because the judge confronts them saying, your client filed a petition, you did not give a certificate. This is a rule that requires it. So make sure that you file a proper certificate. The next provision is written statement repetition. I'm sure that most of you have heard it from judges and from seniors that when a writ petition is admitted to regular hearing, then you have to file a written statement. This is the rule that provides it. Volume 5, Chapter 4, Part J, and Rule 6, you have to file a written statement. This, although I have not included in the handout, it has just come to my mind that some judges issue pre-admission notices. Pre-admission notices. There is no concept of pre-admission notice in the High Court Rules and Orders or in any provision of law. And in a book, Judging with Passion, written by the former Chief Justice of Pakistan, Mr. Khosa, will you remind me the name of yes, the Honourable Mr. Justice Asif Saeed Khan Khosa, and he calls such judges lazy judges. He said, who issues pre-admission notices a lazy judge who does not completely comprehend the case. He doesn't comprehend it enough to dismiss your petition and he does not want to admit it either to be issues a free admission of this. There is no concept of that. And recently, the Honourable Mr. Justice Mr. Vikas Sahib has also given a judgment to that effect. But obviously, it is something, it is something for the judges to follow. The second last, well, the last two provisions are similar, they deal with the same subject. Court fees on writ petitions. Court fees on writ petitions. Now, this rule says that a court fee of rupees 500 shall be payable on each petition. The key words here are each petition. But no court fee shall be required in case a writ is required in respect of the detention of any person by or under orders of any public authority. The second key word, public authority. Now, this gives rise to 2 points. The first one is that no court fee is payable on habeas corpus petitions. But which habeas corpus petitions? The one where the order of detention has been made by some public authority, but not where you file a habeas corpus petition for recovery of a minor who is in improper custody of the father or mother, according to your case. That is where you have to file a court fee. But the word each petition have given rise to some controversy and contradicting views. I have listed here 2 cases. One is an unreported order and dated 24th of January 2017, where the Rawalpindi bench has held that this rule means that you have to pay 500 rupees court fee on every petition, regardless of the number of petitioners, regardless of that. But then there is another reported judgment, CLD 2007 Lahore, in which it has been said that you have to pay court fee according to the number of petitioners. In that particular case, there were more than 300 petitioners. So 300 multiplied by 500. And what had they done? They had challenged an order of the Board of Revenue. All of them were parties for it. Now, I submitted to you as food for thought that this is a charging provision and it should be construed strictly. And to me, the view of the Rawalpindi bench in an unreported order seems to be the correct view. And you should only be required to pay 500 rupees on a petition regardless of the number of petitioners. Because the word used here is on each petition. It doesn't say for each petitioner or some other such word. And the same applies, and by the way, I have used this order in the High Court to get overruled objections of the office. So at Rawalpindi bench, I believe this order is being followed. But anyway, if you come across some officer in High Court who demands more court fee, you can use this order. And then the same provision, similar provision, in the next rule, it applies to inter-court appeals and requires 1,000 rupees court fee, this time on each appeal, not for each appellant, but on each appeal. So you should not be required you should not have to pay more than rupees 1,000 on each appeal. Now, these were the points. Obviously, there are a lot more in that thick book. We could talk on and on, but these are the points that I wanted to cover. I hope that I did not make things overly complicated for you. I was asked by some senior members of the bar to speak in Urdu. I purposefully chose not to do that. We may like it or dislike it, And I have always been an advocate of Urdu being used in all walks of life. I do not approve of English being used. This is one of the major hurdles that we have in progress, especially in law. But I may like it or dislike it. It is not for me to make policy decisions. The law that you deal with, the constitution, the proceedings of the court, the judgment, everything is in English. So I wanted to speak in English to encourage you to familiarize yourself to become more proficient in the language, because it's a quick farani. I will just say one thing at the end. May God bless his soul. Dr. Abdul Basit Sahab, he was my teacher at Punjab University Law College. And the first time when he came to our classroom to give us a lecture, and he had, those of you who know him, he had a beautiful, impressive, deep-chested voice. Not like my sleepy voice. He had a very beautiful voice. You would feel like that, and very impressive. And he asked us the first question: would you like me to speak in English or in Urdu? And he always spoke in Urdu, always. And he was a graduate from the best universities in America. But he asked us the question, and being a cheeky student that I was, I said, "Sir, we are neither masters of English or nahi hum Urdu mein malika hasil hai." This is the sentence that I spoke. And he got so angry, he was furious, and he looked at me and said, "Kya naam hai aapka?" I said, "Imran. Imran, you cannot become a lawyer. Give up the idea. You will never be an advocate." This is what he said to me. But then he said that articulation is the most important thing for an advocate, and I say it with some degree of pride. He taught us for a year, and towards the end of the year, I was the only student that he praised, and he once again asked me, "What is your name?" And I said, "Imran." And he said, "Imran, I can predict you will become an excellent advocate." So, because we, focus on language. So thank you very much for your patience hearing. I hope you learned something.
I want to ask specific that what this word actually means, because I have seen a lawyer who used this word, even the most celebrated lawyer in the history of Pakistan, Mr. Manzoor Qadir. So I was shocked that how this word can be attributed to such a legendary lawyer in the history of Pakistan, the word doubt. So what does this? Because without rational application of mind, we attach such kinds of words with highly dignified and graceful lawyers. So please explain what the actual meaning of this word. For whom this provision is, how judges do like doubting, etc.
Although I did not deal with that subject, but I don't think that question is relevant to High Court rules and orders. The question that you are asking seems to me to be about the conduct of advocates and some judges. I'm not going to comment on that. That is not the sense in which it has been used. There are words that are terms used in a specific context, but then those words are also used in ordinary life. A good example is who is Shaheed. Shaheed has a religious connotation, but then Hindus also call their, the people who die for a good cause Shaheed or martyrs, and even political parties in this country call everyone a Shaheed. So the word has a proper connotation, and it also becomes a daily used word. The sense in which you are using it is an ordinary sense. But the sense in which it is used here is basically it applies to those non-lawyers. Non-lawyers. You will see, or if you go to the civil courts, sometimes you see there are professional witnesses even who charge money to appear as a witness. There are people like them, busybodies, who make it their profession. They go and they gather clients. Sometimes they have a prior agreement with an advocate. Sometimes they just take a client to one advocate and to another, to a third one, in the hope that when the counsel agrees upon some fee with that client, he will give them a share of that. So basically, a person is a scout who brings you, he has no business, he has no concern with that particular case, but he goes and brings his client to you in the hope that you will give him some monetary compensation. He is a scout, and he chooses you not because you are an exceptional advocate or experienced in that particular field, but because you have agreed to give him money. So his motive is not your professional skill, his motive in choosing you is not your professional skill, but the money. So he is a scout. That is the sense in which it is used here. And I'm not going to give any an answer to the political or other connotations of that one. Rule, I cannot read it out. You can see it in volume 4. It actually gives a definition of the word doubt, and that is what I'm using to answer your question.
First of all, along with everybody, I do appreciate and I must appreciate for what a brief and what a beautiful study of so many things, particularly after having 22 years practice, I never been gone through the High Court rule and volumes in depth, as I heard today and as you told. One thing is always confusing for me, sir. What is letter pattern? So I would like to ask you to explain this term as you use in paragraph number 2 of your first page, section 27 of letters pattern dated 1919 constituting the High Court. Thank you.
Another question I would just like to add to this, that whether as of today latest patent is applicable or not.
I have them here. If you have this particular book, it is at page 69. But in other books or publications, it is basically an appendix to the High Court rules and orders. It was a kind of a charter that was issued by the then King of the United Kingdom of Great Britain, George V. And it has a very old language. It is basically like the rules or the basic statutes under which the High Court of Judicature at Lahore was created for the province of Punjab and Delhi. It has a lot of provisions, 37 in number, which basically enumerate the powers of the High Court, and they are the charter under which the High Court came into existence. They provide for the right of appeal, and like I said earlier, there is also provision empowering the High Court to make rules and orders and so on. But basically, it was, for your interest, I will just read the first few lines to give you an understanding of what it was. George V, by the grace of God, of the United Kingdom of Great Britain and Ireland, and of the British Dominions, dominions being India and other overseas dominion colonies of England, beyond the seas, King, Defender of the Faith, Emperor of India, to all to whom these presents shall come, greetings. Whereas by an Act of Parliament passed in the 5th and 6th years of our reign and called the Government of India Act 1915, it was amongst other things enacted that it should be lawful for us, legal us, Shahana Andaz by letter patent to establish a high court of judicature in any territory in British India. So he goes on to say that we create the high court. I don't want to bore you. And it lists the jurisdiction of the high court as well. But to answer the second question, we are now governed by the 1973 Constitution. One thing that we often forget is that when you give a new constitution to a country, basically you are creating a new country. We don't realize that because the territories remain the same. But when you give a new constitution, it is a new country. That is why in the 1973 Constitution you have the definition of the country and you have also the names of its territories and so on. So basically, this is a new high court now that has been created by the 1973 Constitution. Historically, it was the letter patent, but now it is the 1973 Constitution. And all the other powers have now been given in the Constitution itself and the rules. So you will have to read Articles 175 and 172 and those articles to see what I mean. Thank you. I hope I answered the question.
First of all, I would thankful to you for this exhaustive and extensive lecture, giving with the complete knowledge. If one person in page 3 at page 3 regarding limitations in intra-court abuse. First limitation is available for contempt petition. Whether it relates to the Contempt Act or ordinance or High Court rules and orders covers this kind of this.
But I believe that the High Court rules and orders are sure about that. They do not give any limitation. But whether the Contempt of Court ordinance prescribes a limitation, I believe. I'm not sure, but I believe it also does not give any limitation. Is there, how much is it? 30 days? 30. Yes. So the answer is to be found in the Contempt of Court ordinance. Yes.
In one of the footnotes for which we have written down that the CCC Amendment Ordinance 2020 was struck down on the basis of an article in the Constitution that the High Court has the power to make rules with respect to the procedure. My question is, if the Constitution provides High Court the power to make rules with respect to the procedure, can through legislation an act could be passed which could change the procedure altogether, or would it be done by the High Court?
The answer is yes. The answer is yes. The basic lawmaking power remains with the legislature. In fact, if you go to the handout, the rule-making power under Article 202, it starts with subject to the Constitution and law. So the main, and as you know that the main body of CPC is elected by the legislature. And then the schedule is those rules orders and rules contained in the schedule are made by the High Court, or they can be amended by the High Court. But why? Because Section 122 of CPC and Article 202 empower the court to do that. However, the power remains with the legislature. The reason that amendment was struck down, that ordinance was struck down, it had other reasons as well, but the Honourable Mr. Justice Shahid Kareem said that one of the reasons that I'm striking down this ordinance is that it makes some fundamental changes to the structure of CPC, but without consulting the High Court. The High Court had just a while before that introduced some amendments, and the legislature has then made some dramatic changes to the procedure, and his lordship said that because the High Court is not being even consulted in the process. So I believe that then what his lordship was saying was that at least the High Court should be consulted. But the simple answer to your question is that the power remains that of the legislature. So it can